Broadcast is now starting. All attendees are in listen-only mode.
Hello, everyone, and welcome to today's webinar, Top 10 List for Delaware Community Associations, Part 1. Before we get started, I would like to go over a few items so you all know how to participate in today's event. You've joined the presentation listening using your computer speaker system by default. If you would prefer to join over the telephone, just select Telephone on your webinar control panel and your dial-in information will be displayed. You will have the opportunity to submit text questions to today's presenters by typing your questions into the Questions section of your control panel. A quick reminder, if your control panel does close up on you, simply click the small orange arrow to open it up again. I would now like to introduce our presenter, Chad Toms, attorney at Whiteford, Taylor, and Preston. Chad?
Thanks, Ryan. And good afternoon to everyone who's on the web and for the folks that are in the room here. So what I want to get started with is just kind of a brief overview of the topic that we've set forth today, and then a little bit of kind of how I'd like the format to go. And despite the recommendations from the marketing group and Christine, I have said I wouldn't mind taking questions either from the audience or typed in through the screen as we go through some of the subject matters, because I think that kind of allows us to kind of tailor the presentation to some of those concerns that are of interest of some of the attendees. So what we pulled together for this top 10 list, and this is only part one, are essentially the types of questions I find myself answering all the time. So I find that I'm answering some of the same topics for the different clients, and I find that to me it's repetitive, but to those clients it's not, it's new information. So this list is essentially kind of the 30,000-foot perspective of some of those subjects, hopefully to give you a flavor for what kind of issue spot as you move along. And just to give you an idea, I'm going to hit these 5 in this part 1 section, and we'll save 5 more for later because I have a lot of slides to get through in a very short amount of time, so there will be some times where I start to move pretty quickly. So the first 5 that I picked for today are the DUCIOA and the application of that statute, as well as then we're going to talk a little bit about open board meetings. When do we have to have open board meetings? When can we have closed meetings? We're then talking about executive sessions. What can we cover in executive sessions? I'll talk a little bit about budget adoption, and then lastly, I'll get into ballots and proxies and how to use those. So before we really get into that subject, it really makes sense for me to kind of back up and give everybody just kind of a general overview of what the Delaware statutory landscape looks like. So in the slide, and which will be on the screen here for the folks in the room and on the screen, first is Delaware's Unit Property Act. This was adopted in 1963. Now, this act applies only to condominiums. So if in the mid to late 60s you wanted to create an HOA, there was no statute in Delaware that applied to you. This only applied to condominiums. The next statute that we have is the DUCIOA or DUCIOA, depending on how you want to pronounce those vowels. That's the Delaware Uniform Common Interest Ownership Act, and it was adopted effective September of 2009. Now, focus on the uniform part of that code means that this is a uniform code, which means it was prepared by educators in law schools, and it's proposed that any state should adopt this statute. So Delaware essentially took that proposed version of the statute, adopted it with some tweaks and some turns that we'll talk a little bit about as we get going in 2009. And here's the confusing part where we're going to spend a lot of time in one of the other slides is the DUCIOA statute applies to both condominiums and HOAs. So we have one statute that applies to both. There's some cooperative stuff thrown in there, so it's all kind of mixed together in one statute. And it's going to be really confusing because some of it applies to pre-existing communities, some of it doesn't, some only applies to new statutes. So we're going to try to walk you through a matrix to kind of help you determine, and that's really going to be our first subject of today. And then lastly, the Common Interest Ombudsman Act. We'll get into that in part number 2, but that's an act that was adopted in 2014 and created the Ombudsman Office. So for those online, the next couple slides are going to show you, if you want to follow along in the statutes, here's how you're going to find them. For those in the room, we brought a number of statute books. They were on the table. If you want to grab one, you can follow along. So you jump to the next slide. If you're online, here's how you find Delaware statutes. You go to this website, delcode.delaware.gov, and just to walk you through it, Title 25, which is the next slide, is where you would find the real estate type of things. Within Title 25 are both this UPA that I talked about and DUCIOA. So if you look at where we've shown you, if you click on Title 25, Chapter 22 is the Unit Property Act, meaning, back when Chapter 22, this would have been in the 60s. And then if you jump to Chapter 81, here we are many, many years later when they adopted the DUCIOA statute, Chapter 81 is the Uniform Act. So you can access these online. And then just for an example, if you click on DUCIOA, it has 4 sections. They're going up DUCIOA, so forgive me for the way I choose to just flip-flop back and forth in the pronunciations. There's 4 subcategories. And if, for example, we're going to talk a lot about Section 119. If you want to find that, you would click on the general provision there, and then it has all of the subsections up at the top of the website. Let's say you wanted to pick Section 119, because we're going to talk about that a little bit. You click on that, it takes you to the statute. And there's another copy of this in a later slide, because we're going to talk in a little bit more detail about how to dissect this 119. So that brings us really to topic number 1 for today, which is DUCIOA, pre-existing communities. How do I know what applies? How do I know what doesn't? And this is probably one of the most common questions I get, which is, does that section apply to me? Does it not apply to me? Do I have to follow? What if my documents say something different? So in Delaware, this statute was adopted effective of September of 2019. And with some exceptions for small existence, it applies to all communities on a go-forward basis. So if you were born as a community after September 1st of 2009, the entire statute applies to you. If you were born prior to that time, there are a couple sections listed in Section 119 that apply to you. So not the whole statute, only some things. And I'm going to speculate as to why that is. It's because if a developer had created a community prior to 2009, a new statute can't take away vested property rights. We may have a constitutional violation there. So there's certain limitations on new laws taking away vested property rights. So that's why there's this provision that says, all right, well, these are the types of things that don't take away vested property rights. So therefore, that's why in Section 119 that you have that. So if we move on a little bit from there, let's talk about some of these exceptions. So for brand new communities, that's why I put new, we have Section 117, which kind of exempts out small communities, meaning that 2,000, if you're 20 units or less, this statute, for the most part, doesn't apply to you, and I'll get to that in a second. Or if you have a small dollar assessment, so a small dollar in 2009, it was less than $500, and that $500 adjusts annually from inflation. So this year we're up to, I think, around $671, and it'll continue to go up. So what we see sometimes is small HOAs do not have obligations to comply with the statute. If it's a small HOA with, say, a couple $100 of annual assessments, they actually fall under this exception because of the small dollar amount. And we see a number of developers that target that. They try to create communities that fall under that threshold so they don't have to comply, because there's a lot of provisions in the statute that tie developers' hands. But even if you fall under these exceptions, note that last part is you still have to record your bylaws. So if you're an HOA prior to 2009, you did not have to have your bylaws recorded. I get a lot of calls from potential clients that can't even find it. They don't know where they are. Moving forward, everybody's required to file your bylaws. So even if you're a pre-existing community, we're going to talk about that, you got to file those bylaws. That makes sense? All right. And again, I don't want to squelch any. If there are questions as we get into this, for anybody in the room or online, send them in, and we'll see if we can get to them. So let's talk about the pre-existing communities. So if you were a pre-existing community prior to 2009, some portions of the statute are applicable to you with those same minor exceptions. So Section 120 exempts out for 20 units or less, or the small dollar amount. So it's very similar to what we saw for new communities. Same thing applies to pre-existing communities, essentially those smaller communities that are exempted out. You still have to record your bylaws. So what happens is when I get a call from a pre-existing community and they say, well, does DUCIOA apply to me? Well, I have a couple questions. I've got to ask you, well, how many units is your community? What are your annual assessments? And those are the types of information that I need to know before I can say, yes, it applies, or no, it doesn't. And that's a very common conversation that I have when the phone rings. So what happens if it does apply? Well, there in Section 119 of the code, and the next slide lists all of those are the sections that apply to you. I've just kind of cut and pasted them into the provision. If you could jump 2 slides up. So if you take a look, I have a list there of the types of things that apply to pre-existing communities. Notice is one of those. I mean, how do we give notice for meetings? Powers of the Board of Directors, Section 302 is there. Judgment of the Executive Board, Section 302. One of the more controversial provisions is in 303, which deals with when under developer control, boards of directors have to switch from declarant-controlled members to homeowner members. So these are some of the kinds of things that now apply to the pre-existing communities. And that's just the list. I'm not going to go through all of them, but that's really just so that you can see in the chart what are the kinds of things that are applicable to pre-existing communities. Now, there's a number of provisions in DUCIOA that I think are pretty beneficial. And as we kind of go through it, I'm going to say I think these are great new provisions, but they're not applicable to pre-existing communities. They're applicable to brand new ones, but not pre-existing. So some of the ones that are pretty interesting is Section 305, which allows an association to terminate contracts after the transition from developer control. That's pretty useful. You don't want your developer putting a 10-year contract over the association and making them bound by it. Bylaw, Section 306. That's a section of the DUCIOA that actually has a list of a number of things that should be in your bylaws, but not applicable to pre-existing communities. 308A is also a very useful provision. It talks about the executive board meetings, and we're going to talk about that in one of our top 5 today, a little bit. And so the rest of this list, I can just put up there, the insurance, surplus fund, how you adopt rules. These are the kinds of things that the new statute creates, but it's not applicable on a go backwards basis, okay? But let's talk a little bit about the application. So what happens when we have conflicts or changes or new activities that take place for these communities? So what we have, and this is me working through the language of Section 119. So if you happen to have 119 in front of you, or if you're looking at it online, after the list of all the statutory provisions that are applicable to pre-existing communities, you'll see a number of other sentences. And so a lot of those other sentences, I think, is some of the real confusing part of Section 119. But let me boil it down as to what I see in there. So generally, the new statute applies only with respect to events and circumstances after the effective date. So the new statute was adopted in September of 2019. So if something transpired in 2018, you can't point to the new statute. That kind of makes sense. So it's the only thing that happened after that date. What happens, though, when there's a conflict? So that's the next step. So DUCIOA does not invalidate your existing governing documents that do not conflict with the chapter. So with DUCIOA. So what they're saying is, as long as your governing documents match DUCIOA and they don't create a conflict, the new statute doesn't make those provisions invalid. Those provisions are still there. Now, hang on. Here's where we're going to get even more problematic. This is the language of the statute. For condominiums only, if there's a conflict between your governing documents and the new statute, your pre-existing documents control. So just to give you an example, a lot of governing documents may have said the adoption of the budget must be by a vote of a majority of the members, right? Some of us have probably seen that language. Section 324 of the new code creates this inverse process. And we're going to talk a little bit about that allows the board of directors to adopt the budget and then just send it out. It's ratified unless it's objected by the owners. So it's a flip-flop of the process. If your pre-existing documents addressed how you adopt a budget, the new statute says for condominiums, we still follow the old language in your documents, not the new code. And the question then becomes, well, if my documents are silent, which one controls? And that's how we work through some of that language. And here's the confusing part of what's happening today is this talks about condominiums and co-ops. It does not talk about HOA. I believe there's a little bit of confusion in the statute, and a number of us lawyers have disagreed on how that language should be approved. So I think that when you have an HOA and you have conflicting language between the new code and your documents, you want to be very careful. Consult with counsel. We kind of want to work through some of those issues. And just to let you know, there may be a statutory amendment coming that may address that, but it is something that we talk about all the time in that confusion. All right, so turning to the next slide, if you have a pre-existing document and the prior act doesn't control, this is for condominiums only, then DUCIOA will control. So if your pre-existing documents are silent, this is condos only, and the new statute addresses something the pre-existing documents didn't, then the new statute will control it. That makes sense for everybody? Okay. So that's really kind of what we have for the application of DUCIOA. Now, I knew that was going to take probably the majority of my time. Does anybody have any questions on that before we kind of move into some of the real, that was the kind of the heavy part of what applies, what doesn't apply. Now we're going to get into some specific granular issues.
You talk about pre-existing communities. Does the community start when the community starts or when it's completed? How is it classified?
Okay, so the question, if you couldn't hear it on the phone, was how do you determine when your community was born, when were you created? And there's a number of definitions within the statute that determines what a common interest community is, and it normally points to when your documents were recorded. So generally, look at the date that your declaration was recorded with your county, and that would be your trigger.
If you're saying this, that just is address condos and co-ops, it's not speaking to HOAs and maintenance boards?
So the question for those folks online was, does this address HOAs and condos and co-ops? So it addresses them all. It's only the question about whether or not there's a conflict between the pre-existing document language and the new statute. It's clear what to do with a condominium. The statute addresses it. We have a case, there's a case out there that addresses it. As to HOAs, there's no case law yet, and the statute is confusing a little bit on the language. So if it's a condo, straightforward, no problem, apply the language. If you're in an HOA, kind of want to step back and go slowly, you want to make sure that you do it the right way. I would recommend consulting counsel on those. All right, so the next topic we want to talk about is open board meetings. And so open board meetings essentially is when the board of directors get together, they conduct business. Can the owners observe that process? Can they come sit in the room, look over your shoulder, see what you're doing, or hop on the phone and listen to you? So under DUCIOA, at Section 308A and in the Unit Property Act, the Property Act is condos only, there is a requirement that all board meetings be open to unit owners. Okay, so if you were an old condo, always had open board meetings. If you were an HOA, up until this statute was adopted, you may not have had a statutory requirement to have an open board meeting. But here's what happens. 308A is one of those sections I just covered that is not applicable to pre-existing communities. So look at it this way. Here's how I would do it on a rule of thumb. If you're a brand new community from 2019 forward, everybody has to have open meetings. Prior to 2009, if you're a condo, have to have an open meeting. Prior to 2009, if you're an HOA, maybe your documents required it, maybe they didn't, but you have to go and look to see what your documents require as to the HOA. But what I will say, best practices are open meetings. Your community wants to see transparency. They want to be able to look over your shoulder and do what you do. If you close the door and kick them out, they're of course going to assume you're doing things wrong. So the takeaway is consider it best practices at open meetings, even if you don't have a statutory obligation to do so. So what are some of the questions I get all the time, which is, well, we're just going to do this decision by email. Is that a violation of the open meeting requirements? And the answer is, it might very well be. And one of the most common things that we see are conducting business by email, conducting business by telephone, and frustrating that open meeting requirement. So what we always warn you is be on the lookout for that. You don't want to take away from your owners the right to watch you conduct business in an open session by conducting things by email. Now, are there exceptions? Yes, but we would suggest that you want to use them very cautiously and with legal counsel, because sometimes you can get around the open meeting requirement if you have unanimous written consent. So if the whole board agrees on a particular issue, they can all sign a document that's unanimous written consent, and oftentimes that gets you around an open meeting requirement. But one of the other questions I always get on is, well, we're just going to have a work session. And because it's a work session, we don't have to open up that to owners. And what I often warn is, be careful with your work sessions. Your work sessions are defined as typically the process by which the board, several board members get together to organize information to present it at the meeting. But if you have enough people in the room to have quorum, and if you start to have a discussion where I'm trying to convince somebody how to vote on a particular issue, you may have stepped beyond what a work session is and into an actual board meeting. So those things are something to be very cautious about. While we're talking about board meetings, notice is always important. How do your owners get the opportunity to come and observe you in that meeting if you don't tell them about it? So there are requirements to give notice to owners, and DUCIOA and the UPA are different. Interesting, under the UPA, the old Condo Act, all you had to do is post notice on the door to the building. That's not That's not what DUCIOA says. DUCIOA requires notice in writing to individuals unless they've given you permission to correspond with them by email, which is a possibility as well. But just be aware, what are my notice requirements? Also, in DUCIOA, the new section, 308A, again, not applicable to pre-existing communities, but it requires that every board meeting you give owners an opportunity to address the board, to tell you things that they want to tell you about the association. So pre-existing communities might not have that same obligation, but what we're going to say is best practice suggests that you should.
Those boards utilize executive session if they're discussing a legal matter, and that's sort of excuse they give not to open it to homeowners. Is that legal?
So actually, that's a perfect intro into our next session, because executive sessions are one of those things that we talk, I'll answer a lot of questions about. So your question to me was, is it legal to have executive session? The answer is yeah, so long as they're for the right reasons and they're allowed under the statute. So let's talk about that a little bit. So both DUCIOA and the UPA allow for things to be discussed in an executive session. Just so everybody, just in case, make sure we're all on the same page, the majority of your meeting should be open so that owners can hear you discuss, try to convince each other how to vote on a particular issue. But there are some subject matters where we don't want the owners to look over our shoulders. Maybe if it's a personal, one of our employees is having a personal matter, we need to talk about it. We're negotiating contracts and we don't want the details to get out because it may affect the competitive bid process. Or we've been sued, one of my favorites, of course. And we have to talk to the lawyer about those types of things. So those are the kinds of things we go into executive session for. But there's a very different standard. Under the UPA, this is for old condos. It was very narrow. And it says consultation with legal counsel or for personal matters relating to the employees of the council. That's it, period. Those two things under old condos. And by the way, consultations with legal counsel is very limited. It doesn't say talking about litigation. It says with legal counsel. So in some of my old condos, they're always trying to get me on the telephone on a Saturday just so that they can cloak their meeting in an executive session, because they really technically have to have me on the phone for consultation with legal counsel. So that's the very narrow definition. So if you're an old condo and you're still stuck with that language, be cautious. Let's talk about what the new statute allows. So DUCIOA has a much broader definition. So in 308A, the definition is consultation with the association's lawyer regarding or discussion of litigation, mediation, arbitration, proceedings, or contract matters. That's much broader, wouldn't we agree? Doesn't require to have the lawyer on the phone, because you can get, or board discussion of the litigation. So it's a much broader concept. It gives you a lot more flexibility as a board to go into executive session. Labor or personnel matters, and then the list keeps going. The list keeps going. So on the next slide, we have discussion of contract matters. And then the last one is even broader than that, that it's the discussion of any claim from or alleged violation by a unit owner when the board determines that public knowledge would potentially be a violation of privacy. And that's a nice, big, broad category. So that's something to, that you got a nice, big, broad category, but if you jump to the next slide, that comes from one of those provisions that's not applicable to pre-existing communities. So let's go back to that analysis. If I'm an old community, that language might not protect me. I might not be able to take advantage of it. If I'm a brand new community, yes, I have these broader provisions. And just to let you know, on the horizon, I serve on a committee where we're talking about making that provision applicable to pre-existing communities. So here we are, September 24th, for the record, 2019. That's what the landscape looks like today. It may change in the very near future.
Quick question. On the executive session, every board that has minutes, we have an open board meeting, there's minutes, and there's executive session minutes. I was advised that I cannot disclose those. If a homeowner comes and requests to see all records, I was told that those are not.
So the question was, if we take minutes in an executive session, are those minutes supposed to be shielded from owners that come to review the minutes? And the answer is generally yes, and let me expand a little bit on that. What I say with minutes in executive session, they're not required by the statute to take. Some communities choose to take minutes. Some communities don't choose to take minutes. But if you choose to take minutes, keep them segregated and separate from the regular minutes. And so finally, on the executive session, let's get to some of the practical takeaways. What I recommend following Robert's rules is somebody should make a motion to go into executive session. So I make a motion to go into executive session for the purposes to discuss and list one of those categories of things that we just went through. The second point, decide if minutes can be taken. Perfect. We've already covered that with your question. And upon ending the executive session, confirm whether decisions were made in the executive session. So that's kind of your takeaway for the executive session. So that brings us to top list number 4, budget adoption process. The UPA was silent. So old condos, the documents were silent on how you adopt the budget. So some communities addressed it in their documents, some didn't. What would happen in those cases, it was really confusing. So the new statute has come along in DUCIOA, and it has created this, what I would call it, an inverse of the adoption process. So in section 324, it's a process by which it's a lot easier for communities to now adopt a budget. And so I have a slide that sets it up. Let's jump to the next one. So the board must, 1, adopt the budget. So this is the board adopting the budget, not the owners at a meeting. Then the board gives notice of the budget. They mail it out to everyone. They set a date for the ratification. And here's the important language. The budget is deemed ratified by the statute unless a majority of owners vote to reject the budget. So what happens is it requires your owners to actually take some sort of affirmative action to come and vote against that budget. Otherwise, that budget controls. So this new statutory provision, I keep saying new, 2009 was a long time ago, it makes the process of adopting this budget much, much easier. But remember our cautions from before. If you have conflicting language, like if your documents told you how to adopt the budget in the past, you may be stuck with that language as opposed to the new statute. And then one other thing before we move off from the budget adoption process is that both the UPA and DUCIOA now require contributions to the repair and replacement reserves. Okay. But let me clarify that. Condos only. Condos only have to have a repair and replacement reserve every 5 years, and they have to fund and be fully funded under those repair and replacement reserve studies. So, and we could probably talk an hour or two on repair and replacement reserve studies, but something to keep that in mind while we're talking about budgets.
Does it speak to condos prior to 2009?
Yes. When DUCIOA was adopted in 2009, they actually went in and amended the UPA to make the requirement for funding reserves the same. There was a phase-in period, but that's long gone. 2017, you had to be fully funded. Okay, that brings us to the last subject, ballots. How am I doing? I got 2 minutes left, 3 minutes left. We're not too far off schedule, so we're good. Proxies versus ballots. I get questions all the time about how we do this. So let's talk a little bit about that terminology. So a proxy is used to cast a vote at a live meeting for an owner who can't be present in person. So if I can't attend the meeting, I can give John Smith my proxy, and John Smith can show up and vote for me. That's what the proxy lets me do. A ballot is generally the process by which an owner can vote without a meeting. So if we're going to have a vote, but we don't want to put everybody in one room, we can use the ballot process. And now there's a section of DUCIOA, section 310, that referred, sorry, before I get to that, but let me just say, I know ballot's a general term. Under Robert's rules, the chair of the meeting can decide how voting happens at a meeting. Sometimes the chair may decide we're going to do a hand vote. When you see your hand, yays and nays, that's called a voice vote, or a paper vote. And oftentimes when you use a paper vote, you're going to call that a ballot as well. So that's where sometimes there's to be some confusion. I'm telling you, use a ballot to vote when you're not at a meeting. Sometimes you are still using a piece of paper at a meeting being called a ballot. So I know that can be a little confusing, so I apologize if it is. But here's why I'm saying the ballot should be used for voting outside of a meeting. So section 310 of DUCIOA says, if you want to have, I'm jumping ahead on slides. Can you jump 2 slides ahead, 1 slide ahead, and then we'll come backwards. So if you want to have a vote without a meeting, the statute requires you to do a couple things. And what that is you've got to give written notice to people and indicate the number of responses needed to meet the quorum requirements. You have to state the percentage of the approvals that are needed. You have to specify the time the ballots must be received by. And then here's the big one at the bottom. You have to describe the procedures by which unit owners are allowed to deliver notice to each other or communications on the subject. And what that is, think about it this way. If I were to show up at a meeting, I could stand up and voice my opinion on why somebody should vote a certain way on a particular issue. Don't vote this way because of that. Don't vote the other way. When we take away the meeting and all we're doing is mailing out a ballot, homeowners are potentially not being able to communicate with each other to encourage how a vote should happen. So this balloting under 310 requires you to tell your owners, well, if you really want to send a mailing out to everyone, everyone and tell them what you think about this issue. Here's how you do it. So that's what the statute requires if you're going to use ballots without a meeting. Can I back up? I think I forgot to hit one slide. I wanted to talk a little bit about proxies. So there's no form proxy in the statute. We all draft our own proxies for the circumstances. So just something to keep in mind. Most governing documents don't require proxies, but don't most communities draft proxies and send them out with their notice? Most do, just for convenience purposes. So the two things to remember with that is that the proxies really shouldn't be purport to be revocable without notice. This is what's in the statute, and they should be for a year or less. They can't be anything longer than a year. Those are Delaware statutory requirements. All right, so I wanted to end with, I'm pretty close to on time except for some of these questions, that there are some practical tips for proxies. So proxies are not required, but we often encourage people to use them because it lets you get quorum at meetings and those types of things. So when you draft your proxies, you can draft them a lot of different ways. You can draft them for just quorum purposes. That way you get quorum. You can draft them general, uninstructed, which means that the proxy holder can vote however they choose to at a meeting. Or you can draft them instructed, which is that the proxy holder can only vote a certain way. So I spent a lot of time talking about proxies. I spent a lot of time revising proxies and helping communities come up with proxies. So there is no, I get asked all the time, can you send me your form proxy so that we can use it? Well, there really is no form proxy. It really depends on what are your circumstances, what are you trying to vote on, an election, it's just a budget issue. So it's something to think about on those proxies. So that really kind of wraps us up, brings us to any final questions. That's kind of the top 5. I think we kind of blew through them and pretty close to the 30 minutes we were shooting for. I apologize, there's a lot of information to throw at everybody at one time. So I'm happy to take any other questions, and I think I have a couple ones here. Anybody in the room have any while I'm reading them?
What's a proxy ballot?
Proxy ballot is, so by the way, proxy and ballot, proxy/ballot is not defined in the statute, nor is an absentee ballot. Right? So we all use those phrases. So it really has the phrase, it has the meaning you intended it to mean, because it's not a statutory definition for it. So I'll tell you what I think a proxy ballot is. I think a proxy ballot is where people have combined the two concepts. And it's the same thing I would call an instructive proxy, which is I'm signing the proxy so that John Smith can vote for me, but John Smith is told how he must vote on a particular issue. So that's the ballot piece of it. So John Smith has to vote yes or no on this particular issue. That's how I look at it, and that's how I would also consider an absentee ballot accomplishing the same thing, which is I can't be there, but I want my vote to count, and this is the piece of paper by which I accomplish that. Okay, one of the questions was, can I get a copy of the presentation? So yeah, the intention with this is that we're expecting that this should be available on our website, the whole presentation, but if you want a paper copy of these slides, I don't have any problem with that. Just send me an email, and we're happy to make them available to you.
Similar.
Okay, so I think that was what the presentation, that's all about the presentation materials. Is there anything of substance? Were there any other substantive questions that came in? Oh, good, good. All right, so I'm happy to open it up for anybody else.
And there's just a couple more.
Because they're working on revising, I guess, the coverage of HOAs and maintenance work. That's the majority of what we have in Delaware. Because it is, when I first moved here, I was given Sequoia, and the person I worked for before was an attorney, and he broke it down and had like a structure. If it falls under here, and the year, the date when the property was reported. That's the same issue I've ran into where a developer broke ground and for whatever reason it defaulted, didn't go through, and it sat dormant for a number of years. When it actually, the declaration got recorded, it will fast forward past 2009. But the record plan, I believe maybe was before that. So there's kind of like, I don't know where to go. So you're saying right now is a gray area with HOAs and maintenance, we should contact council. To be honest, a number of them I've asked the question, they're just, I don't get a straight, I get 2 different answers from 2 different attorneys.
So if I could recategorize your question, just in case they can't hear it on the speaker that's right next to me, I believe your question was, in situations where it's confusing, is there an easy-to-use matrix as to whether or not the Kiowa is applicable to a pre-existing community? Is that right?
Sure.
Okay. I don't think there is. And the reason I say that is I've written a number of written opinions about whether or not the statute is applicable to this particular community under this particular facts. And I can tell you it's tough, because sometimes the record plan came in before the statute was amended, but then the declaration wasn't, and then there were amendments back and forth. So I don't think it's easy. It's easy in situations where everything was recorded and everything started before September of 2009, or the vice versa, everything happened after. When you have those communities that kind of straddle that line, where they kind of started but kind of stalled and then kind of got revised, they're problematic. So if you have one of those, I would just ask that you can get a legal opinion as to whether or not it's applicable to that particular community. But I would also raise that I'm of the opinion that a number of the provisions of the statute are useful. If your community, if you can get the votes, I would recommend simply amending your documents to make clear which provisions do apply. The statute encourages people, encourages communities to vote to move into the statutory provisions. So I've had a number of communities that just pick and choose. They go through the list and say, I want that one, I want that one, I want that one, but I don't want these. And they pass an amendment voted on by the owners and pick up those provisions that they want and leave behind those that they don't.
And unless the documents are conflicting, wouldn't it be better just to practice, if there's been board meetings, notice on, kind of follow something than the DUCIOA statute?
So
unless your documents conflict that. I mean, in Florida, that's how it is. It's, you have to notice board meetings. You have to, do certain things. So if you can encourage your board to do that, wouldn't you just do that?
Yeah, so the question was, isn't the majority of the Kiowa what we consider best practices? And I think I would say yes. However, we've talked about the procedural stuff, notice, adopting budgets, open meetings. There's a lot of stuff in there that are obligations. For example, resale certificates and a lot of disclosures and books and records. So there's obligations in the statute that some communities don't want to have to comply with because they're costly. So with the good comes some bad.
Okay, thank you.
All right, well, I think, Ryan, we're going to kick it back to you. Thank you.
All right, thank you, Chad. And thank you, everyone, for attending today's webinar, Top 10 List for Delaware Community Associations, Part 1. If you have any other questions, please contact Whiteford, Taylor, and Preston. Please stay tuned for information coming soon regarding Top 10 List for Delaware Community Associations, Part 2. On behalf of Whiteford, Taylor, and Preston, thank you all for joining today. Please have a great rest of your day.
Thanks, Ryan. It's a little weird doing it with the